Too drunk to remember, but not too drunk to face the consequences.
Good morning, everyone. Today is the 10th of December. It was a jury day, I mentioned yesterday. We had 3 cases scheduled. Ms. Camfield from the prosecutor's office has been on top of these cases. 2 of them are with Attorney Tim George. He's also been on top of his cases. One of the cases had to be adjourned, and
this jury trial vanished in seconds, and the courtroom wasn't ready for why.
We've moved that into 2026. That leaves 2 cases for today, and we're about to resolve one of them. So we will not be having a jury trial this morning. The other defendant, in fact, has not appeared. So this may be it for the record for today. But before we start, I'll give today's first line. Yesterday was night moves. I said it'd be on my top 20, no matter top 10, no matter what the list was. Today's first line is, LA proved too much for the man. Too much for the man. He couldn't make it. So he's leaving the life he's come to know, and he's going back to find what's left of his world. It's all funky when you just read it straight out. But if you add some pips, you'll know what the song is. All right. The only common denominator is those are songs that I like. So thank you for our little short moment of humanity. Now let's get down to actual business. You got it. All right, with our actual real business, we're going to address Mr. Alexander Bryant Conley. Mr. Conley is here with his lawyer, Mr. Tim George. As indicated, this matter was set for jury trial this morning. Angelique Camfield from the prosecuting attorney's office is also here. The defendant was charged back in June on the 26th with operating with a high blood alcohol level, possession of a firearm under the influence. We attempted a plea at one time and didn't quite get there, so the matter was scheduled for trial. The defendant, according to the police report, was quite intoxicated and does not have a real clear memory of everything that took place that night. That is the quintessential reason for a no contest plea. If you plead no contest, you don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. So lack of memory is a clear reason for a no contest plea.
No memory, no denial, just a no contest plea that changes everything.
Even if you remember some of it, if you don't remember all of it. Ms. Camfield, what is the plea offer?
The plea offer, Your Honor, was a plea to the lesser included offense of operating while intoxicated, first offense, as well as a guilty plea to, no contest to possession under the influence of a firearm.
Let's break that down. Operating with a high blood alcohol is a misdemeanor. It's punishable by up to 180 days in jail, fine of up to $750, requires that your license be suspended, and it carries 6 points. Possession of a firearm under the influence is a misdemeanor. I think it's only 90 days and or $500, but it does require forfeiture of the gun. This was a nice gun, a Sig Sauer, as I recall. But the statute requires the gun be forfeited and the state police destroy it. The prosecutors agreed to dismiss the high blood alcohol count for a charge of just plain old operating while intoxicated. Operating while intoxicated is, they used to call drunk driving. It's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 6 points on your driving record and also would require that your license be suspended. My understanding is you're going to plead no contest due to a lack of clear memory of these two charges. Is that correct, Mr. Conley?
Yes, sir.
All right. This is your waiver of your advice or rights. By entering this plea, do you understand you'll be giving up your right to have a trial here today?
Yes, sir.
Anybody threaten you to get you to plead to this?
No, sir.
Or promise anything?
No, sir.
I'll make you one promise. We won't do this till after Christmas.
I appreciate it.
So I don't know what the sentence is going to be, but we'll get through the holidays and I'll set this in January of 26. So do you plead no contest to those two charges?
Yes, sir.
All right. There is a bond information report in here from the arresting officers.
The judge pauses the sentence, but the consequences are unavoidable.
At about 1:30 in the morning on June 26th, the police got called out to Custer Road. That's in the northeast corner of the county, close to Branch and Calhoun counties. They found you, actually a Centerville officer was the first person there, in these people's yard. You had, for reasons I don't completely understand, pulled into their driveway and knocked over some of their landscaping. You were a .265. They found a handgun, a Sig Sauer, underneath the passenger side back seat. And there's a video that shows you driving the truck into the driveway. Then you fell through a basement window, plexiglass cover, and cut yourself. But 265 is more than 3 times over the legal limit.
Your Honor,
Yes?
the lab result came back as a .228.
All right. Thank you.
And that is correct. I concur with that. And for purposes of the record, the laboratory scientist was Abigail Hawk, Hawke.
3 times over the legal limit, with a loaded firearm in the truck.
And that is laboratory report number TX25-9347.
Mr. Conley, do you live in Lawrence or do you live in Union City?
Union City, sir.
All right. So the Arbogast Road is correct?
That is correct.
All right. Very good. Are you working someplace?
Now, I receive total and permanent disability from VA.
All right. Well, we'll hear more about that when we do the sentence. Let's find a date that works for all the parties. January is a little tricky because I'm going to be gone for some of it. Mr. George, are you good for Monday, January 26th at 11?
Yes, sir.
Are you?
I am, sir.
All right, very good.
Your Honor, just for purposes of the record, may I presume then the court made a finding of guilt after that factual basis?
Good point. Do you accept that factual basis that I recited from the bond information sheet
I do, Your Honor.
as supplemented by you and counsel from the blood alcohol information?
Yes, of course.
Mr. George, are you
I
satisfied?
agree, Your Honor.
All right, very good. Mr. Conley, I want you to take this form out to the counter. We'll find out more about you, more about the incident, whether you're in any treatment, what's going on, before we do the sentence. It's quite a ways out, farther than I'd like to go, but as I said, I'm going to be gone for part of January. So you're good to go. Thank you for being here, as I said, in a timely manner. And we'll see you in
January sentencing is coming, and mercy is not guaranteed.
January 26th.
Thank you.
Don't leave yet, Mr. George.
Thank you, Your Honor.
Thank you. 11 a.m. Mr. Gary is a no-show. I have a couple of phone numbers. Have you tried to reach him?
We've been playing, the office has been playing phone tag with him, Your Honor.
All right.
Your Honor, I have some information that I have provided to counsel that I can relate to the court as well. Apparently, the victim called our office this morning and spoke with Ms. Lambert, inquiring as to whether Mr. Geary needed to be present this morning. She was informed that the message called off only the witnesses, not the defendant, and the defendant did need to be present. During that conversation, Ms. Lambert did hear a male in the background that's presumed to be Mr. Geary, thus the question during the phone call. So I believe he was probably informed, as well as having been provided his date earlier this morning through that call, that he was to be present.
All right. Well, I'm going to do a bench warrant with a 48-hour hold.
Thank you, Your Honor.
He has a no contact provision, but I think they're probably in contact every day. I'd like to resolve this case. But Mr. Geary, if you're out there, or Ms. Brown, or anybody, Daniel was supposed to be here this morning to meet with his attorney regarding this scheduled jury trial date. The file number is 251579SM. He's charged with interfering with a crime report and domestic violence. You are not here as required, so I'm going to issue a bench warrant for your arrest in the amount of $1,000 cash or surety. And we'll do a 48-hour hold, meaning you have 48 hours to contact your attorney and present yourself here at the court. All right, that's all we can accomplish this morning. We'll be in recess. I do have some things to attend to. One of my Rotarian colleagues passed away, and there's a funeral this afternoon, so I may be attending that. All right. Let's close the